I'm Attorney Dan Marr from the Nashua, New Hampshire law firm of Hamblett Kerrigan. I've been practicing law here in New Hampshire for approximately 38 years, 37 in this firm and 1 year clerkship. And then with the Commonwealth of Massachusetts, I've been practicing for about 28 to 29 years. I'm going to be talking today about how you get rid of, how you remove a occupant of property that you've inherited in New Hampshire. So in New Hampshire, you may be in a situation where you are a trustee of a trust and you're charged with your fellow beneficiaries to remove somebody from a piece of property that is now trust property, or you might have gotten the property through a will. I'll explain that in a moment. So under a trust, sometimes estate planning documents are such that they're called revocable trusts, and your father, your mother, your uncle, somebody that you've inherited the property to, left it as in a deed in a revocable trust, and then when they passed on, it became irrevocable, and then you became the trustee, and you're responsible for taking care of the property. You might also be in a situation where there's actually a will that says this, that says specifically that you get the property, or you might be in a situation where so you go through probate in the will situation, or you're in a situation where the property is in what's called joint tenants with right survivorship, where you're not really actively involved, but when your father passes away, your mother passes away, your uncle or whoever, it automatically turns over to you. And the problem is you got somebody in there, and they don't have a lease. They were friends of your relative that gave you the property, or in some other circumstance, maybe they were the former boyfriend or girlfriend of that person, but there's no formal arrangement in that situation. In that situation, obviously, you want to talk to them about the possibility of a cordial moving out of the property, but you want to find out quickly about what they're saying is the situation that they have with the decedent being the person that got the property. They may claim that they put major investments into this property and they're actually were always treated as part owner of the property. They may say that they're a common law spouse, and under common law spouse under the statute in New Hampshire, you have to prove that you were together for 3 years prior to one of you dying, so that would be the decedent. You were living together, cohabiting together, you were acknowledging yourselves as husband and wife, and you were reputed in the community as husband and wife. Very tough standard in 2025 because, for one, people are not embarrassed about saying that they're living in sin. They're not living in sin anymore, as they were back when this statute was created in the, I think, 1700s or 1800s. So people are normally living in a relationship. They're unmarried couples, so they're not acknowledging themselves as husband and wife. Also, people in the community know that they're not married. So in that situation, you don't be able to prove common law spouse. So there's them showing that they have a agreed to arrangement or some type of constructive trust arrangement with the decedent that they actually own a property, or they're just a occupant of the property. If they don't have a lease that is a defined term in there, and it probably isn't if they're a friend of the decedent, then they're an occupant at will, and it's a month to month, and you can actually evict them for good cause, saying that you want to sell the property or whatever else you may truly want to do with it. Maybe you want a relative to move into the property, but that's good cause. You can do that under there's something called a eviction notice, and you fill that out. It's a form that's available. You probably should talk to an attorney about it. Then if they don't get out by that period of time, you can do what's called a landlord-tenant writ. You do not want to check, even if they were paying rent before, you don't want to check the box in the first page that says that you want to claim a small amount of rent that's allowed for in there, because then they can bring counterclaims. You don't want to do that. If you actually go forward with they don't move out by the eviction notice and you have to go to court with the landlord-tenant writ, if they assert that they have some ownership interest in the property, you want to test that with your attorney and see whether or not you can get a bond also from them posting a bond before they claim and deny eviction by claiming a property interest in the property. So you want to explore that all with your attorney. But I wouldn't move slowly on this. Talking to them and hoping something works out makes it, you can still talk to them, but you still can give them that eviction notice that gives them some finality that they have to move forward. I've been dealing with this for, again, 38 years, and I'm happy to talk to you about it. I'm at Hamblett Kerrigan at NashuaLaw.com also is the website, and you can check out the website and go on to NashuaLaw, all one word.com. Check out my bio. click on the vlogs, and you can see my vlogs by topic, and you can call me at 603-883-5501, Dan Marr, 603-883-5501. I hope I can have the opportunity to work with you if the opportunity so arises. Thank you.